Yes.
Lordship. Listing of writ petition, Lordship, relating to non-payment of salary, Lordship. Can be on 6th of December, Lordship.
No. It go to January.
January, any date, Lordship?
January 8th. 8th of January.
January. Obliged, Lordship. Please, the Lordship. On the matter, my Lord, come up for admission, my Lord.
Admission.
Next week, my Lord, anything.
Admission will be on 23rd. 23rd January.
Obliged. May I please, your Lordship, I beg to mention item number 29, kindly pass over the matter for the date.
20. Item number
29.
29.
Yes, Lordship.
You are mentioning on whose behalf? On whose behalf are you mentioning?
P.K. Roy Choudhury.
Item 29 is the request of Mr. Your name?
D. Talukdar.
D. Talukdar, making a mention on behalf of Mr. P.K. Roy Choudhury. Matter stands passed over for the day.
Obliged, Lordship.
Yes. Yes.
The matter pertains to non-payment of arrear of salary, my lord. Petitioner was initially appointed in pursuance of the Honorable Guwahati High Court order as stated, my lord. So Annexure 1 is the, my lord, his appointment as a sweeper. Thereafter, my lord, his appointment as a sweeper was cancelled and accordingly he was appointed as a peon, my lord. Within the period when he was working as a sweeper, his payment was not paid, my lord. In the earlier occasion, the court has given direction to the respondent forest or finance officer.
Yes, forest and finance.
Lordship, appearing for respondent in finance department, we haven't got any instruction as of yet.
So, my lord, basically the non-payment of salary when he was working.
Your representation is pending.
Already pending. So, lordship, kindly see.
We will dispose of the matter with a direction to address your grievances on the basis of the representation which you have filed.
Lordship, kindly see Annexure 6.
6.
It is a very important annexure, my lord.
Yes.
So, where the office has, they themselves accept that they have not paid my salary.
That's right. So,
so it is so, lordship, when I'm working, it was not only Article 14 violates, my lord.
no, that's all right. So we'll direct them to look into your grievances on the basis of this application.
If lordship is possible to give direction to pay this.
Yes, we will direct them to look into your grievances. Yes. Mr. Dhar?
My lord, yes, it seems that that page 20, it's pending. So, my lord,
we'll direct them.
The authorities will look into it according to law, my lord. If he is eligible, he will get it, my lord.
Even, my lord, lordship, kindly, I have already mentioned in annexure, they have accepted that I have, so it is, I have repeatedly paid my representation, my lord.
My lord, there cannot be a, my lord, mandamus, my lord, at this stage. Only, my lord, if my lord will direct that, yes.
But when the matter non-payment of salary, it amounts to be a forced labor, my lord. So non-payment of salary by the state authority, my lord.
Then, my lord will issue notice, my lord, is in motion stage.
So, my lord, lordship, kindly dispose the matter, whatever, my lord.
Hard learned counsel for the parties. Mr. Dhar for?
My lord,
government.
No, my lord.
Forest.
Finance, my friend is appearing, my lord. I will appear for the forest department, my lord. Forest consultation not here now.
A.
A. Borthakur.
A.
Respondent 8.
A. Borthakur appearing for respondent number 8.
My lord.
Mr. A. Dhar.
R. My lord.
R. Dhar, learned senior counsel, senior government advocate appearing for the forest department. This writ petition is filed by the petitioner praying for grant of arrear salary due, stated to be due, to be payable to the petitioner. Stop. the petitioner was appointed as a sweeper pursuant to this court's order dated 3/8/2006, passed in WPC 3875 of 2005. He joined in his services as a sweeper on 23/5/2015 and has been accordingly rendering his services. Stop. However, his office order, however, his original appointment was cancelled by the PCCF, and the petitioner was appointed by issuance of a fresh order and posted in the same office on the same day. The issuance of a fresh order on the same day and posted in the same office. Stop. The grievance of the petitioner is that his monthly salary for the period with effect from 23/7/2015 to 18/12/2016 has not been paid. He had represented before the authorities concerned. However, the authorities will have not resolved this issue, and no orders having been passed by the concerned authorities, the petitioner has approached this court for grant of specific orders. Stop. This court earlier had permitted the Standing Council Forest to obtain the instructions as to why the area salary has not been paid. When the matter is listed, Council for the Forest not being available, the court has requested the assistance of the learned senior government advocate, Mr. R. Dhor, to appear on behalf of the department council. Mr. D. Gogoi. Yes. Mr. D. Gogoi appears on behalf of the council, Forest Department. The petitioner appears to have filed a representation before the authorities by the representation dated 5/11/2022. The representation is pending, so we will direct for disposal of the representation. Stop. By the said representation addressed to the PCCF, the petitioner had requested for payment of his area salary for the period mentioned, which is 23/7/2015 to 18/12/2016. Stop. This representation is shown to have been received in the office of the PCCF. However, no orders have been passed. Stop. Learned Council for the Forest also does not have any instructions on the status of this application representation, considering the issue involved in the matter and considering the fact that a representation preferred before the respondent authority is already pending. This court is of the considered view that the writ petition can be disposed of with a direction to the PCCF to expeditiously dispose of the representation dated so and so pending before the authority. And thereafter pass appropriate orders in the matter. This direction, besides being issued to the PCCF, is also being issued to the respondent finance department. Respondent number 8. Stop. Both the respondents, PCCF, respondent number 3 and respondent number 8, will address the issue raised by the petitioner, and thereupon pass a speaking order in respect of the grievances raised by the petitioner. Stop. This exercise we completed within a period of 60 days from the date of receipt of a certified copy of this order. Writ petition stands disposed of in terms of the above.
Obliged, my lord.
May it please your lordship. May it please your lordship. In this case,
Yes.
the basic challenge in this case is that the basic challenge is in this case is a notice impugned order which has been passed by the Director of Higher Education. Item number 2 to 12 are similar matters, although they are all associate professors and some are principals, and 2 of them has retired by now. But the issue in this case is one and common. That is, these people who are granted 3 advance increment in pursuance to an office memorandum issued by the UGC. And the state government has issued that office memorandum in 2012 and has granted these 3 increments. Accordingly, we are drawing these 3 increments. But all of a sudden, one fine day, by impugned order dated 25/2019, this 2 impugned orders was passed. The first, the increment which we are drawing was stopped. And secondly, there was a direction for recovery of this increment issued to the principal of the respective colleges. Now, I'm challenging this on 2 grounds. First of all, there is no reason as to why this increment should not be given to us, which has been bestowed in pursuance to an office memorandum issued by the UGC. Secondly, before passing that impugned order, we are not put on notice. Because your lordship knows it very well, when there is a financial implication, it is a civil consequences which is bestowed on the petitioner. So when an action of the authorities have a civil consequences upon the persons, they have to be put on notice.
Tell us, where is that notification?
Yes,
UGC
your lordship.
notification.
So lordship takes up the item number 1.
Lordship, may I interrupt, Lordship? Lordship, here in this matters, Lordship, records were called for, Lordship.
No records are necessary, your lordship. This is
Lordship,
often
we
a
have-
short
Why
case.
don't you allow him to submit? Yeah.
Lordship, we have received records for 2 items, the first 2 items, the rest yet to be received, Lordship. Can we pray for a, Lordship, fixed date, Lordship?
Let me first understand what is the issue about.
Yes, Lordship.
What is the issue here?
In your lordship,
Where is that notification? UGC.
if your lordship is taking up item number 2,
We are taking up item number 1. That first
Vibhuti
matter.
Chaudhary, 4521.
4521. Yes.
Yes. Your lordship will kindly come to page 41.
Page
41.
41.
Incentives for PhD. Incentives for PhD, MPhil and other higher qualification to take effect from 1/9/2008.
Hmm.
In pursuance of the recommendation made by the UGC by Regulation 2010, dated 36/2010,
Hmm.
the state government finance department has notified the UGC scale of pay to the teachers of the government degree colleges / provincialized colleges and non-technical teachers of engineering colleges by notification number such and such dated 11/5/2010, and after receiving concurrence from the finance department, the government of Assam Education Higher Department has conveyed the same for implementation of revised UGC scale in university colleges by later dated such and such. The state government in Education Higher Department, after careful consideration and examination, has decided that in keeping conformity with the UGC recommendation, it is necessary to ensure observation of eligibility incentives for PhD. It is categorically stated eligibility incentives for PhD, MPhil and other qualification to the teachers of university and colleges, librarian as mentioned below. PhD degrees, these are all the common things. Your lordship will turn to next page 42.
Yes.
Number 10. The teachers in service awarded PhD under the earlier scheme regulation on or after 1/1/2006 and by the time of coming into force of this regulation shall be entitled to get 3 non-compound increments if such PhD is in a relevant discipline of employment and 1 advance increment in case of teachers in service who have been awarded MPhil degree. I'll pause there for a moment, your lordship. So this notification categorically states that 3 advance increments will be given to all those teachers who have completed their PhD during their services on or after 1/1/2006. So the cutoff date is 1/1/2006. And I've just read the operative portion that this office memorandum has been issued in pursuance to the direction and the regulations by the UGC. And these higher education institutions are bound to comply with the direction issued by the UGC. So accordingly, we are being.
Oh, where is the UGC notification?
Your Lordship, the UGC notification has been annexed by the UGC Council in their affidavit.
Hmm.
I'll come to that, Your Lordship.
No, that is the basis, isn't it?
Yes, Your Lordship.
Where is that notification?
Yeah, if Your Lordship kindly see the Vibhuti Chaudhary,
The affidavit filed by UGC.
yes, Your Lordship, respondent number 10.
Hmm. Clause number 9.
If Your Lordship turns to page 57,
Yes.
point 9.5.
Yes.
In respect of every other cases, a teacher who has already enrolled for PhD shall avail the benefit of 3 non-compound increments only if university awarding. Yes, Lordship 9.6, I'm sorry. Teachers in service who have not yet, no. I'll just.
Yes.
Just coming to your Lordship. Lordship 56, Your Lordship. 56, I'm sorry, Your Lordship. 56, 9.4. Teachers who complete their PhD degree while in service shall be entitled to 3 non-compoundable increment if such PhD is in a relevant discipline of employment and has been awarded by the university complying with the process prescribed by the UGC for enrollment, post-work evaluation, etc. Now, Your Lordship, as per this, we have been given the increment, Your Lordship. Page 45, Your Lordship, of the writ petition, Annexure 8.
No, what is the mandate of the UGC notification? That is what I want to see. Why don't you point that out?
Your Lordship, this is the only mandate.
What is
Because
the mandate?
the mandate is that, I've just read it out, Your Lordship.
Teachers who complete
Yes, Your Lordship.
while in service.
Yes, Your Lordship.
Now, from which date this cutoff date will be counted? From which date you will be given the increment?
Your
The
Lordship,
day you enroll or the day you complete?
the day we complete, Your Lordship, there are various.
All right. So you completed PhD when?
I completed my PhD on 7/9/2007. So I'm well within the cutoff date, Your Lordship.
7/9/2007.
Yes, Your Lordship. That is at page-
Completed means you have been awarded your PhD.
Yes, Your Lordship.
Okay.
And the notification which I've annexed in my writ petition is said it should be, the cutoff date is 1/1/2006, Your Lordship.
Hmm.
So accordingly, I've been awarded with 3 PhD increments. That is at page 45
Hmm.
of the writ petition.
Yes.
May I read, Your Lordship?
Yes.
In pursuance to the government OM number such and such dated 27/4/2012, which I've annexed, Dr. Vibhuti Chaudhary, Associate Librarian in the Department of Library of LCB College such and such, is hereby allowed 3 non-compound advance increment with effect from 1/7/2001 for acquiring PhD, raising scale to such and such, giving financial effect from 1/7/2011 with date of next increment 1/7/2012. Your Lordship, we have been drawing this. There was no dispute to that. And all of a sudden, Your Lordship, now the impugned notification is at page 51.
Hmm.
In terms of the government instruction contained in OM dated such and such, and in supersession of earlier order issued such and such, the 3 non-compounded in advance increments are hereby allowed to Vibhuti Chaudhary, Librarian, LCB College, Maligaon, Kamrup, with effect from such and such date, raising his pay to such and such with DNI 1/7/2009 in the scale of such and such for acquiring PhD degree on 7/9/2007 instead of such and such. Now the next para is important. The principal LCB College Maligaon is hereby directed to calculate the amount payable to the teacher concerned due to the advancement of the date of the advance increment with effect from 1/9/2008 from 1/7/2000 to 1/7/2011, along with the calculation of overdrawal of salary resulted due to allowing of advance increment with effect from 1/7/2011, and take necessary steps for adjustment refund of the excess drawal amount to the effect exchequer through treasury challan. Your Lordship, the notice does not say what was the wrong in awarding us with the advance increment, first of all. Secondly, they have asked to recover the amount. Now, stoppage of increment is a penalty, first of all. Secondly, it has a civil consequences on the person upon whom it has been bestowed. So when you take such a drastic step, a person.
You are allowed how many increments?
3 increments, Your Lordship.
Only 3.
Yes, Your Lordship. Advance increment.
Okay. Now their stand in the affidavit is that you were entitled for these increments with effect from 1/9/2008.
Yes,
So how many increments from 1/9/2008 will you get?
3 increments, Your Lordship.
Which dates? Which
Your Lord-
years?
We have been allowed now. In this case, I was allowed financial effect from 1/7/2011.
So the stand of the government is you are entitled for 1/9/2008.
Yes,
And however, you were given the increment from 1/7/2011.
yes, Your Lordship.
Now, there is no dispute in the number of increments.
Yes,
The dispute is the calculation of the benefit that you will get on the increment.
right.
Now, this calculation has to be done on the basic salary.
Yes, Your Lordship.
So, your basic salary on 1/9/2008 and 1/7/2011 is bound to be different.
Yes. And in fact, after 2016, it is more different, Your Lordship.
So, the calculation which they made and the financial benefit you got was made on 1/7/2011, from 1/7/2011,
Whatever.
which is at a higher slab.
Yes, Your Lordship.
Then when it ought to have been in 1/9/2008.
Right,
If it was 1/9/2008, it would have been at a lower amount.
right, Your Lordship.
So to that extent, the
Yes,
government's view is that there was an excess payment.
right.
So that excess payment they want to recover.
No. Well, the excess pay, they have to point it out. What is the excess pay? And why this excess pay was there?
They'll point it out by way of calculation.
No, Your Lordship, nothing was done, Your Lordship. Your Lordship, I can put it.
No. The fact of recovery, etc., is to be done by the college authority.
Exactly, Your
So
Lordship.
have the college proceeded?
Yes, no, nothing.
They have not proceeded. So as and when they proceed, you will be entitled to know what amount
Your
is
Lordship-
required to be recovered.
Your Lordship, our increments has been stopped. And they are
No, that is what I'm asking you. This is a cumulative increment, or
cumulative, Your Lordship.
you are allowed 3 non-compounded advance increment.
So, Lordship, it's cumulative, Your Lordship. Once given, it's given. It will continue with us, Your Lordship. There is nothing as such, it's one time. Your Lordship will see, their reading of this order does not say that it has been overdrawn, over excess. Of what amount? Why? Nothing. Your Lordship, on the face of it, Your Lordship, this can be disposed of in a direction that setting aside this, because no opportunity was given to us, Your Lordship.
What opportunity will be given to you? No
Your Lordship,
opportunity.
Your Lordship, whenever there is a financial implication, I can put it, Your Lordship.
No. Giving you the benefit of increment, was any opportunity given to you, whether you are eligible, not eligible?
Yes,
No.
Your Lordship. Your Lordship, all those persons only who are eligible can apply for
That's
it.
right. Somebody who may not have been eligible, they can have a claim that my case has been rejected without giving an opportunity.
Your Lordship, first of all, one has to get a PhD and one has to get within that cutoff date, Your Lordship. This has been given by the UGC.
What is the cutoff date starts from?
1/1/2006, Your Lordship.
2006.
Yes,
So
Your
you got your PhD in
After that.
7/9/2007.
7. So you are within that cutoff
Yes, Your-
period.
yes, Your Lordship.
The only dispute is that instead of the 2007 or 8 from where you should have been given an increment, you were given increment from 2011.
Right, Your Lordship.
Now, in calculation of that amount,
The-
your basic salary will change by that time
Definitely. So
with
from
great pay and everything.
Your Lordship, they suppose they have implemented the increment from today. So whatever is my basic pay, it will be calculated on that.
That's right.
So again, when the pay revision will be there, the pay commission will come and pay revision will be there, it will again increase, your lordship. So there is no dispute to that. The only grievance raised by me at this stage is that they have stopped these increments and they have directed for recovery of the entire amount, whatever has been paid, which they could not
Yes.
have done.
Lordship, we have directed the principal to calculate the excess royal, Lordship.
Hmm.
Only then, Lordship, we have not.
No, first tell me, is it 3 increments or is it a cumulative increment?
Lordship, it is 3 include.
Only 3,
Yes,
thereafter nothing.
nothing.
Are you sure? Where have you stated in your affidavit?
Nowhere, your
That
lordship.
affidavit is not very clear, Lordship. That's why the records were called for by order dated 17/8/2023, Lordship.
Who has filed this affidavit?
Lordship, this is filed by the department, but it was filed
Who in the department?
by Higher Education Department.
Who in the department? Which officer?
Lordship, it is the Director of Higher
So
Education.
director's affidavit is not clear according to you.
In fact, your lordship, this order does not speak anything why this increment should be stopped and why this recovery has been made.
Yes, Mr. Gogoi,
The entire. relates to
it is
the
at your
agreement.
instance all these things have happened.
So we have
You
given
don't
the-
want to release increments and if you do, you want to get it back again. Now, what is the issue here? It's only a cutoff date.
Yeah, yes, the other is the issue of cut-off date.
It is not a case that they are not entitled.
I know.
But if it is a cumulative increment, then how does it matter?
Right.
You can always adjust it.
Yeah, yeah.
It is only if it is 3 increments and no further.
Yes,
So
But
what
here-
is the actual position?
Lordship will kindly see page 51, second para again, my lord. May I read this? The principal, LCB College, Maligaon, Kamrup is hereby directed.
No, that is the
It
calculation.
appears to be only three years, my lord. But what I am saying is,
Ah,
to calculate the amount payable to the teacher concerned due to advancement of date of advance increment with effect from 1/9/2008 to 1/7/2011. That is 8 to 9, 9 to 10, 10 to 11. Along with calculation of overdrawal of salary resulted due to allowing of advance increment with effect from 1/7/2011 and take necessary steps for adjustment refund of the excess royal amount to the government exchequer pro treasury salary. So whoever has got beyond 1/7/2011, that is more than 3 increment, that was directed to be recovered.
no, that is the question. It is clear from your order that this is what you want. Question
Well,
is why?
Well,
Why do you want to recover it?
from what it appears, it is only 3 increment, my lord. Lordship will see, my lord, page 45 for a moment, my lord.
45.
Yes.
Yes.
In pursuance of the government OM dated 27/4/12, so and so in the Department of Library of LCB College, PO, so and so, is hereby allowed free compounded advance increment with effect from so and so. For acquiring PhD degree, rating pay of so and so in the so and so, give financial effect from 1/7/2011. So here, my lord, it appears, my lord, the present petitioner got after, my lord, 1/7/2011.
Hmm. So what does your record say?
Lordship, the records are with Mr. K. Gogoi, Lordship. Only for the first 2 items we have received, Lordship.
So first 2 items you tell us. First item you tell us.
Can this be taken after some time, Lordship?
Your lordship, let him get the records, by then I'll enlighten your lordship as to why with 3 or 2. Your lordship, the increment does not say that it will be given only one time. As a one-time measure, it is nothing like that. Once you acquire the PhD within this framework, you'll continue to get it. And in fact, your
It
lordship,
doesn't say so. It says only 3 non-compounded advance increments. That's
Yes, your
all.
lordship. Yes, your lordship. It
Then-
says it will continue with me. Your
No.
lordship. Yes, your lordship. In cases of other persons who have received this, they are continuing with it. It was only in our case, your lordship, this order,
Anyone for the UGC?
UGC.
Your Lordship, I am appearing on behalf of A. Sumo. Your Lordship, he is busy in some other court.
You are here, you enlighten us, you be here.
In fact, the affidavit also does not say it's one time, your lordship. It
Hmm.
says that in terms of the UGC recommendations, these have been paid.
Your also short date may be given.
No. Be responsible when you make submissions to court. Yes. You want to go through the records. We'll take it up after a while. After a while. But before the court rises for recess.
Yes, but
Yes. You tell us from your record what is to be done. It doesn't appear to be something that requires, breaking of heads.
Only
Doesn't
the thing,
require.
the higher education will have to place the policy under which they will be entitled for 3 or more than 3. That's it.
That's already I placed. with
As
your
I've
lordship.
understood, it is only for 3,
My
which is
lord,
why
my lord,
perhaps you are asking for a refund.
My-
Because this will be calculated
from one,
on the day, on the basis of, if it is calculated today, it will be calculated on your basic salary. If it is calculated after 3 years, it is again calculated on your basic salary, which will be higher.
In fact, your lordship, after 2016, what I have drawn in 2011, the increment, it increased because there was a pay revision.
That's right.
Every time there is a pay revision, it will increase, your lordship.
But if it is cumulative, then I don't see any reason for recovery.
Yes, sir.
You can adjust it.
If there is something wrong. And more importantly, we have not been put on notice of what is the defect, what is the wrong, where is the miscalculation. Nothing has been put on notice. Your
Your notice is irrelevant
No, your
because
lordship.
you accepted it without notice.
Exactly. No, I am eligible for it. Therefore, I've accepted.
No,
it,
no,
your
no, no.
lordship.
You have accepted you have accepted some increase to your basic emoluments.
Yes, your lordship.
But the question is, you have not been able to project that this recovery is not called for under the provisions of law.
Yes, your lordship.
Not being put to notice is not a good ground
Your lordship,
alone.
when there is a financial implication, it is a civil consequences. your
No,
lordship.
financial implication is there because you have been given that benefit. You have
Yes.
accepted it.
Yes, your lordship. Now they want to withdraw it. We have to be put on notice. Your lordship, there is a Supreme Court judgment exactly on this issue. I'll place it, your lordship.
How will you explain it? Assuming you are given a notice.
Yes,
How
your
will you explain it? Tell us.
The reason is that,
You are unable to tell us whether it is cumulative, not cumulative.
your lordship, I have stated it's cumulative, your lordship. Had it been the case that it's not cumulative, it would have been stopped then and there itself, your lordship. The reason is that they have not cited any reason why they have stopped it, your lordship. It's cumulative in nature. And since 2011 to 19, till this notice was issued, I have been receiving it. In fact, after the pay commission also, I have been receiving it at the enhanced rate, your lordship.
All
Fixed
right,
by the
we'll
pay
take
commission.
it up after a while. Yes. Before we write.
May it please your lordship. Lordship, I have received the updated instruction, my lord.
Hmm.
Regarding the area salary.
Now, what is the status here?
We have released to the treasury officer, lordship. Second phase, my lord.
You have released.
My lord.
Yes, it has been released. You must have received it by now.
I have no information, Lordship. I am to obtain instruction.
Obtain your instruction. It is submitted by MSMD Bora, Learned Standing Council,
WMD department.
WMD
MD.
Department,
Okay.
that the area salary of rupees 166,332 in respect of the writ petition has been sanctioned and released to the Treasury Officer, Bilasipara Treasury, Dhubri. Stop. It is submitted that the petitioner may have received the amount already. para learned counsel, MS so and so appearing for the petitioner, submits that she has no instructions and prays for Monday, prays for a day's time. Let the matter be listed again on Monday.
Lordship, may keep my instructions a part
The
of the
copy of the
record.
instructions is kept on record.
Lordship, I'm deeply obliged, my lord.
Monday, list on
Ma'am.
Monday.
Lordship, deeply obliged.
Sorry, 4th. Yes, Mr. Sormani.
My lord, I'm issuing the order of suspension, my lord, of the petitioner who was appointed now board on selection.
Hmm.
He was suspended on the basis of one FIR filed by one Zainal Abidin, my lord, making false allegations that I was underage. The minimum age for Gaupura is Gau Pradhan nowadays is 25 years. And the FIR stated that I am 23. On that ground, I was suspended. Then the criminal proceeding was initiated. But this court granted bail, ensued bail, and he was not. And then he was granted bail and anticipated bail. Now, I have annexed this original issued certificates, including the birth certificate issued by the Health Department, Government of Assam, and the Seva issued certificate also. He was 26 years, some days, on the date he applied, and he was called for minor interview. Anyway, in the meantime, after a lapse of 3 months, 12 days, DP was drawn, my lord. But without giving any reason, there was no review of the suspension order beyond 3 months. After lapse of 3 months, and no reason was recorded as per the Ajay Chaudhary case, one your lordship knows, 2015, Supreme Court.
Where is the impugned order?
Every page 25, my lord.
25.
Yes.
Yes. So you've been in suspension with effect from 21.
Yes.
So who, any other person in charge of the office? No other person.
No.
What is the stand of the respondents?
Now,
if any?
they have, my lord, after filing this writ petition, my lord, on 18/3/2023, 22, they have issued the 22, no? 23. After about 1.5 years, they have issued the department proceeding, charge sheet. DP was drawn. Not within 3 months, and after 3 months also, they have not reviewed this order of suspension. And thereafter, charge sheet was handed over to me on 29/4/2020. 22.
We have already filed an affidavit, my lord, here. After inquiry,
What is the status now?
status now, my lord, that is of the lordship directed to obtain instruction. And we have sent a letter on 24/11/2023, my lord.
From
We have
whom?
not received anything, my lord.
From whom? From whom?
For our deputy commissioner, my lord.
Of which place?
Yes. My lord, I will obtain instruction.
Which district?
The Borpeta, my lord.
So we should follow the deputy commissioner. It appears that your clients are very busy in giving you instructions.
No,
We
my
are
lord,
rolling matters on the basis that instructions are not forthcoming.
No, my lord, maybe, my lord, Dipam Boda, he sent it, my lord. My lord.
How is it that a senior government advocate seeks instructions in matters of court and the DC is unable to give you instructions?
Another aspect is also there, my lord. Departmental proceeding has concluded on, or I don't know.
That is what we are asking you. You said you don't know.
I don't know, my lord. I have not.
You
received
get it
instruction.
tomorrow.
Another.
Tomorrow, get it tomorrow, or we call the DC here in office, in court. What is this? You are keeping a man under suspension. How are you operating the office of a Gaupura? It is under a statute.
Tomorrow, madam.
Tomorrow. Get the instructions. What is the status? Mr. Sharma will take it up tomorrow.
Lordship also let me verify. He is a duplicate certificate issued by the Seva.
You can't verify.
No, my lord.
Let the authorities verify, get your instructions, what is the status, we'll pass orders.
Regarding certificate issued by SEBA, being a standing council, I can inquire it.
Not necessary. because the department has already proceeded
Yes.
against him. Now, over and above that inquiry, you want to conduct another inquiry on your personal behalf.
No, not personally behalf, my lord.
Then,
The lordship direct me, then
no, why should we direct you?
if not direct, I will not do it, my lord.
Why should we direct you?
Tomorrow, my lord,
It's just, you want to remove him, you remove him. You are keeping a man under suspension. You are not proceeding with the inquiry. When you seek for instructions, your DC doesn't give you
departmental
instructions.
proceeding has been drawn, my lord. That has been drawn.
No, drawn means it has to be brought to a logical end.
It is 2 years now. He served.
All right, Monday. We'll give you time till Monday. Let the
Monday,
matter be listed again on Monday.
Okay.
By which time the learned senior government advocate, Mr. T. Chotia, will obtain instructions with regard to the status of the departmental proceedings stated to have been proceeded against the petitioner, who is under suspension presently. Stop Mr. R.P. Sharma, Senior Counsel, assisted by M.S.T. Som, appears for the petitioner. Copy of this order we mark to the office of Additional Senior Government Advocate in order to enable him to requisition the required instructions as prayed for. List on 4th.
Obliged, my lord.
May I please, Your Lord. This is the appointment, Lordship. The petitioner was appointed by the court order, Lordship. The court order is page number 23, Lordship. While the court directed to appoint him as compassionate appointment because his father is killed by some extremist. Thereafter, Lordship, what happened, Lordship? They appointed me in 2013, Lordship, page number 26. In the appointment order, they have stated the court order also, and the finance department also approval also there, Lordship. In the appointment order, last line, Lordship, the post has been approval of finance department by number amendment dated 2008, so and so. Thereafter, Lordship, what happened, Lordship? Till date, they have not paid my salary, no regular salary also and arrear salary. Without any salary, I am still working, Lordship. Some irregularity is there, Lordship. For that, Lordship, the page number 29, the director of, at that time, the director of Madrasa Education issued some letter, Lordship, instructed to Dhubri Treasury Office to release my salary, Lordship. The first letter, Lordship, page number 29. The letter issued by the director of Madrasa Education at that time. Second, Lordship, the page number 30, the another letter, Lordship, in respect of my salary, they requested to release my salary, Lordship. In this case, Lordship, what happened, they have filed the affidavit also. The irregularity is there, Lordship. In the court order, Lordship, they have directed to appoint me as compassionate appointment, Lordship. But they appointed me, call my record, Lordship, and the director directly appointed me by this appointment letter, Lordship. Till date, they have not issued anything, Lordship, no salary, nothing, Lordship. Now they filed the affidavit that there are some irregularity. But irregularity is the part of the director and the government, Lordship. This is not my fault, Lordship. If anything done, Lordship, any irregularity done by the government, Lordship. But they cannot stop my salary, my regular salary, Lordship. I am working since 10 years, Lordship.
Yes.
But this is not a case of compassionate appointment, my lord. This is not a case of compassionate appointment. For compassionate appointment, there is a procedure, my lord. That procedure has not been followed in the instant case. In fact, he was working. My lord, kindly please come to page 39. The application he has submitted before the Commissioner of Education Department, my lord. Page 39.
Yes.
Every different.
I have the honor to state that late Jasimuddin Khan, ex-fourth grade employee of the Said Madrasa, but sir, in his service period, he was murdered by extremists, and from that time, I am working as a fourth grade employee against my deceased father post to till now. But sir, my service is not regular due to negligence to Deputy Commissioner of Dhubri and Kokrajhar, Assam.
Yes.
So he was temporarily working in
No,
the
no,
post, madam.
How
Nothing else.
temporary? Appointment letter is there, Lordship. Irregularity mentioned by them, Lordship, at that time.
Where is the appointment letter?
Yes, Lordship. Page number 26, Lordship. How is irregularity done by them, Lordship? That's why I file my application. Kindly complete my irregularities, Lordship. This is not my fault, Lordship. They have to follow the procedure, Lordship, because the court order is mentioned here, Lordship, and finance approval also mentioned, Lordship. This is not a fake appointment. It's a government appointment.
Appointment, but without following the procedure.
Yes, Lordship, the following the procedure, they have to follow, Lordship.
No, they have
But
not followed.
At least they have to release my current salary, Lordship, because I am working.
Your procedure for appointment has not been followed. So therefore, your entry into the service is irregular, illegal, or irregular at least.
Lordship, it may not be irregular, illegal, Lordship.
It may
Because
not
my
be illegal,
father
but it
died,
is
Lordship.
irregular.
Because at
See,
that time,
was there any advertisement? Was there any selection, interview?
it's a compassionate appointment.
Compassionate. So compassionate, you know the procedure. Names will have to be forwarded to the DLC recommendation,
Yes,
placed
but-
for SLC. Was anything done like that?
But that part, Lordship, on that respect, the retrospective effect,
No,
they have to regular my appointment, Lordship. The
Why?
director also,
No, on what ground?
because appointment was made by the director, Lordship, and I am a
Maybe,
grateful employee.
you
They have
may
to
be, you
follow
may
the-
be absolutely correct, but the appointment itself is not regular.
They have to regular, Lordship. It is not my fault, Lordship. How can I understand the irregular and irregular?
Then you,
I am the grateful
what is
employee.
your, have you represented before the authorities? What have
Yes.
they stated?
But the authority itself forwarded different letter, Lordship, the page number 29 for needful action.
What action can be taken now?
Nothing has been done still, Lordship. Neither release my current salary because I am
Is the
working.
post approved under SIU?
May I point out one document, my lord? The petitioner has been submitting that his appointment was made pursuant to approval of the finance department.
Hmm.
Possibility page 30 for a moment. This is from the director
30.
to 30, annexure 7.
Hmm.
The last two lines of the first para. The post has been approved, a post has the approval of the finance SIU department, white number so and so dated 1/3/2018. And the validity of finance SIU department expired on 31/7/2008. Now, my lord, appointment was made in 2013.
Hmm.
There was no approval on that day. And that appeared, my lord.
So therefore, ex post facto approval to be granted.
No, for that, my lord, they will have to move and they will have to show that, my lord, he has been appointed through a regular process, my lord. Here, lordship will kindly see the para 3 of the writ petition. Page 8. After the death of the father of the petitioner, he applied for his appointment in place of his father before the authority, including to the department. On his application, the managing committee so and so by resolution dated 22/8/2006 appointed the petitioner as Chowkidar of the state madrasa school on temporary basis.
Yes.
But where is the statement that he has applied for compassionate appointment?
No,
He applied before the managing committee. Managing committee is not the authority to make the appointment on compassionate basis.
Lordship,
And
you
that
must
is
say
But the
managing
appointment
committee
orders
appointment.
were issued by the director.
Yes.
No, that is expressly illegal. Expressly illegal, man.
After 10 years, they have said this is illegal.
Well, either he will make a submission or we will make a submission. Man. Let him complete, then we'll make.
What is the direction of the court? Where is the order of the court, earlier order?
No order, my lord, page
Page
23.
25.
11% of page 25.
Twenty-five.
25, my lord.
The last parameter.
In terms of the guidelines.
Now, Lordship, you will see, my lord, page 26, the beginning line. The director's order says in compliance of the order of the Honorable Court passed on so and so in WPC so and so and as per resolution 4 dated 22/8/2006 of so and so. The managing committee, the petitioner's name is there. He is hereby appointed
is hereby appointed as grade 4 in the scale of pay. My lord, nowhere it is stated that, my lord, the SLC has finally recommended. In fact, my lord, there is a wrong interpretation of the Honorable Court's order. There is, my lord, as per Honorable Court's order, he has been now appointed. Honorable Court, my lord, pointed out regarding the guidelines for compassion in the court.
Now, what is your, you are still working?
Yes, still working.
Salary is not been
No,
released.
no, thank you. Lordship, if their officer misunderstood the court order, Lordship, I am a grade 4 employee. Is it my fault, Lordship? Appointed by their officer, is the director at that time.
Yes.
In case of compulsion department, he has to submit an application before
Whatever is to be done
But
is
that has not been done,
to be given by the authorities concerned.
that has not been done, madam, because he has to approach the authorities.
Oh,
madam.
Mr. Counsel, you see, in government departments, it is the government department who will decide how, do you dispute this order at page 26?
This is an illegal order, my lord. This is an illegal order.
What steps have you taken against the director?
No steps has been taken because
Then how can you say it is illegal? On
It's-
what
it's
basis you
this-
are saying this is illegal?
my lord, if you have not taken any steps against this person, that doesn't mean that this order is legal, my lord.
No,
This is an illegal order.
very well, but
Explicitly illegal
on
order, my
what
lord.
basis are you saying this is an illegal order?
Because this order, my lord, this order was apparently passed in compliance of this order, my lord, passed by this honorable court. But to comply with this
No.
order, my lord, there has to
There are two things. You see, it may not have been passed entirely in terms of the directions issued by the court. Procedure may not have been followed. Would that order be considered to be illegal? Hardly you have an authority to recall this order. You have not done it. All these years from 2013, 10 years, you have allowed the man to work. Why?
No, my
Not
lord,
an illegal
because
order.
no, my lord, we have not allowed him because he was appointed by the managing
But
committee.
has it been cancelled?
My lord, no, this is
Then
not cancelled. But
This is
thing
an order
that,
of your department.
thing is that, my lord, this director of madrasa is no longer is there, my lord. It is no longer is there, my lord.
You're beating about the bush. You
So,
see,
my lord,
this is
His appointment.
this is an
was-
order of the department.
Yes.
Whether the directorate is there, not there, amalgamated or recalled, fact remains that this is an order of the department. Today, let us say you are bifurcating the Department of Secondary Education into more than one. Does it mean that all earlier orders issued by the Director
No,
of
my lord.
Secondary Education
I'm
are
not
become
saying-
illegal?
I'm not saying that, my lord.
Then
But this order is illegal.
the order was issued at the time when the Directorate of Madrasa was there. You have chosen not to recall this order, modify this order. Your only ground is that this is an illegal order because procedure has not been followed.
Yes, my lord.
It is not for you to say, it is for the department to take a necessary step in this matter. Have they taken any steps?
No.
Nothing. They've allowed a man,
No, my lord, we have not allowed, my lord. Because thing is that my
your
lord,
actions
his-
have allowed.
his appointment was made by the initial appointment by
It
the
has not been cancelled, Mr.
Managing committee,
Karunia. What stops the department from withdrawing or cancelling this order?
we have not till now, my lord. As per my knowledge, my lord, we have not withdrawn this order.
Then
But we can do it, my lord.
we are not asking you to do it.
No, no, I am not saying that.
What we are
we
saying
can-
is
we can-
that
we can do it.
a person has been given the hope of getting employed, getting a salary, he's working.
No, my lord. This is because since he earlier he has approached this honorable court, he very well know about the fact that the procedure of compulsory appointment, my lord. He has not followed, my lord. My lord, can you see this?
He may not have followed. Fact remains what prompted the department to accept his candidature without following the procedure.
We have not
Department is
accepted.
aware.
We have not accepted his commitment. Kindly see this order, my lord. We have not accepted his candidature as a compulsory appointee, my lord.
No, you have given him appointment.
One,
You have given him appointment in a post where you say that it has approval of finance SI.
in fact, that approval has already expired, my lord.
Very well. It can be renewed.
That approval has.
Yes, finance.
That part I cannot say, well, until and unless the proposal goes and the department examines, but these things will come up. And secondly, my lord, moment the honorable court said that the guidelines will have to be followed, then, my lord, in that case, it will start from the, my lord, application submitted by the petitioner. Only then it can be considered. Guideline is, my lord, cannot be that only you make place it before the DLC. First, my
You
lord,
get
we
a
have-
report from from where are you working? Madrasa.
Now it is secondary.
Where are you working?
Dhubri, Madrasa, Kasarigao Senior Madrasa.
You get a report from that madrasa regarding your service.
And one more thing, my lord, whether
From
he,
your concerned inspector or DE or whoever is in
Inspector, madam.
charge.
whether he's otherwise he has got the educational qualification, even for commissioner appointment, he will have to have the minimum qualification for the post of grade 4. Now, no statement has been made in the writ petition. At least to that effect, some, my lord,
You get the information from the madrasa about his service.
Yes, madam.
It is 10 years since his date of appointment. Whether he has rendered service, what service has he rendered, all details you get it. Heard learned counsel for the parties. This writ petition is filed with the petitioner, aggrieved by the fact that notwithstanding his appointment issued by the Director of Madrasa Education, Bhaidi, order dated 11/6/2013, in a grade 4 post in the Kacharigaon Senior Madrasa. His salary has not been released. Stop. Grievance of the petitioner is that he is continuously rendered service in terms of this order, and for reasons best known to the department, his current salary, arrear and current, has not been released. Stop. It is his submission that he is still continuing to render his services in the same madrasa. Stop. Where Mr. N.J. Khatoniar, Learned Standing Council, Secondary Education, submits that the order of appointment of the petitioner is without following the procedure of law, and that too, procedure prescribed, and that too, in a post where the finance within bracket SIU department approval is not there. Stop. He submits that this is not a compassionate appointment as the procedure prescribed has not been followed. Therefore, no benefit can be granted to the petitioner on the basis of the order dated 11/6/2013 being passed by the director appointing the petition. Whereas Mr. P. Gogoi, Learned Standing Council Finance, also submits that this appointment order has been made to a post where the finance SIU approval had already expired in the meantime. Stop. He submits that for renewal of approval, due proposals will have to be forwarded to the finance department by following the proper procedure. Stop. Upon due consideration of the proposals as may be forwarded, the finance department will decide whether sanction is required to be granted or not. Stop. Considering the fact that there is no dispute that considering the fact that there is no dispute that this order dated 11/6/2013 was indeed issued by the director of madrasa at the relevant point in time, appointing the petitioner in the grade 4 post in the so-and-so madrasa, to consider passing effective orders in the matter. This court is of the considered view that the particulars and details with regard to the services rendered by the petitioner in this 11/6/2013 be called for by the education department and placed before the court by the next date fixed. The details should reflect whether the petitioner has been rendering services as claimed before the madrasa and whether any payments, if at all, have been made. Stop. The status of the same madrasa in respect of the department will also place before this court the any particular, any specific details as may be relevant in respect of the functioning of the Said Madrasa, if so required. Matter be listed again on eighth of January,
Obliged.
2024. 2024.
In this case, my lord, in the earlier round of litigation, my lord, there was an order passed by this honorable court. At judgment was at page 95, my lord. Operative part is at page 99, para 9.
Yes.
Under the aforesaid circumstances, when there is a specific statutory provision dealing with interest in delayed payment of pension, this court is of the opinion that the Commissioner Secretary of Higher Education will be the competent authority as provided under sub-rule 2 of Rule 197A of the 1969 rules to determine as to whether there was any administrative lapses. If there is a finding by the Secretary to that effect that there was administrative lapses for delayed payment of pension, obviously the petitioner would be entitled to the interest on delayed payment for pension and pension. So this was the operative part, and it was directed to be done within 3 months. Thereafter, my lord, this order was passed, judgment was passed on, my lord, 5th of March 2020. Then after 3 years, my lord, they passed a speaking order at page 107,
Yes.
wherein there was no any independent assessment made by the Secretary, my lord, basing merely upon the information received from the Director of Higher Education. He has passed the order. From accordingly, my lord, accordingly, as per the information received from the Director of Higher Education, the petitioner Dulal Krishna Putra, retired so has already enjoyed his pensionary benefit following all procedures and norms fixed by the government time to time, and it is found that there is no administrative lapses either from the government or at the director level. There was no any independent assessment made.
What independent assessment is that? He has to call for records from the subordinate authority.
Yes, that is true, my lord.
How will he make an independent assessment? What is the report? Where is that report for information from Director of Higher Education? Is it available?
Lordship, we have filed our affidavit, Lordship.
Is that report available?
No, Lordship, that has not been annexed.
Get that report. Let us see what the director has said.
Lordship, I can get that. Apparently, there was delay, my lord, because the person retired in 2006. And
Yes, but then you filed a contempt also.
I had filed a contempt.
So what is the status of the contempt? It
It
is
was closed,
closed.
my lord. After this order was passed, this was closed. Or this matter can be remanded back to the Secretary, my lord,
For what?
for a fresh assessment, my lord.
On what basis?
Because, my lord, as per Rule 197A, my lord, he has to make an independent assessment, and this affidavit has been filed by the director, not by the Secretary, my lord. If my lord may kindly peruse the order passed in this petition, my lord, the first order passed on 24/5/2023.
Hmm.
In this case, my lord.
24/5.
Yes, my lord. Para 5. It further appears that the Commissioner and Secretary of the Government of Higher Education Department was served a representation dated 18/5/20 by registered post on 22/5/20. The same was repeated by another communication dated 3/9/2020. In pursuance thereto, a speaking order was passed almost 3 years on 10/4/23. In the speaking order, which was challenged in the instant proceeding, there is no reference as regards any consideration so made in terms of the observation made in para 9 and 11 of the judgment dated 5/3/2020, passing WBC 3450/18. Taking into account the same, the respondent shall apprise this court as to whether there has been compliance to the judgment and order dated 5/3/2020, passing so and so on the next returnable date, and as to whether there was any administrative lapses on the part of the respondent authorities, entitling the petitioner for delayed payment of interest under Rule 197.
You show us the report of the director on the basis of which the secretary has passed the order.
Otherwise, Lordship, they have referred to the order dated 5/3/2020, Lordship, passed in. It's there in the speaking order, Lordship. I'll get the report, Lordship, which was furnished to the secretary.
When can you get it?
After 10 days, Lordship.
Why 10 days? It is already there on the basis of which the secretary has passed the report.
Lordship,
Passed the
today
order.
is date. Can it be on 9th, Lordship? Sorry, Lordship. 9th is the second. Lordship, 7th, Lordship, in that case.
7th, all right. Matter be listed on 7th, on which date? The Standing Council, Higher Education,
Yes, Lord.
will place before the court the report
Submitted by.
submitted by the Director Higher Education on the basis of which, where is the impugned order?
Lordship, page 107. Order dated 10/4/2023.
On the basis of which the Commissioner and Secretary
Yes, Lordship, secretary.
to the Higher Education Department had passed the order dated 10th of April 2023, presently impugned in the writ petition. Stop. The report be placed before the court for perusal of the court on the next date fixed, list on 9th,
7th, my lord.
7th,
7th.
7 December.
Obliged, Lord.
May
Yes, Mr. Bhuya.
Yes, my lord, here has been a lady, my lord, wherein she retired from service on 31/12/2021. Now, my lord, the regular pension, then the gratuity amount, arrear pension that has not been released. Now, factual matrix is this, my lord, that in that particular school wherein I was in charge principal for a time being, my lord, and a regular selection was held. There has been a dispute with regard to respondent number 5, who has been appointed as regular teacher. Now, on a particular day, my lord, I sought leave from the school on held ground, and it was allowed. And in the meantime, I have stated in paragraph 5 that another person has been made the in charge principal, Ranjit Day. Now, thereafter, in my absence, this selection order came in with regard to respondent number 5, wherein he has been appointed as the regular principal. Now he took unilateral charge, and thereafter, he ought to have processed my pension papers, and the pension papers, including the no liability certificate and the audit report. That it is the role of the principal of that particular college, my lord. But I retired on 31/12/2021, but it's not been processed. Now, after filing of this writ petition, my lord, certain amount has been released. The respondent number 5 has filed his affidavit, my lord. And according to him, my lord, the same dispute, my lord, with regard to that, he cannot file no liability certificate and the audit report, my lord, that he have stated before this honorable court in paragraph 18, my lord, of his affidavit in this. This particular amount, which was in my hand, my lord, I have mentioned it in my writ petition itself, my lord. I have tendered this amount to the principal. He refused to take, my lord. I tendered it before the inspector of schools. He forwarded to the principal.
What did you tender?
My lord, when I was in charge principal, Saraswati Puja, unaudited amount and audited amount of 6,000 something, and certain amount is being stated to be in my hand, my lord. That in the affidavit in opposition they have annexed, my lord. Will kindly see. May I take your lordship to page 142? That is the affidavit in opposition, respondent number 5.
Yes.
Amount of 6,852 auditable, miscellaneous amount 23,770. Now, these two amount I have tendered to be accepted when I came back from my medical treatment. Refused to be accepted, my lord. I tendered it before the inspector of school. He forwarded it to the my lord principal. He refused to accept. In return, he filed an FIR against me, wherein I have been short-sheeted. Lately, my lord, I filed a revision
with a delay condonation petition with regard to revisional, invoking revisional jurisdiction, my lord, that review petition was allowed and the matter was stayed by learned session judge. Against that, they approached before Honorable High Court, this principle, approached before Honorable High Court for against that particular, my lord, delay condonation petition. It was dismissed. And till now, my lord, the revision has to be heard. So what I am on, my lord, that no liability certificate as per paragraph 18 as per affidavit, my lord, he has stated 6852. Miscellaneous expenditure 237. Hold this amount, my lord. I am ready to tender it, provided he accepts it. My lord, in the court of law, my lord, wherein the FIR has been filed, my lord, will kindly come to, my lord. I have adduced the evidence also, my lord, wherein he accepted that I have tendered, but he refused to accept it, my lord. That is at page 105, my lord. What is my alternative now? As because the dispute has been there, he is taking personally, my lord. 105, kindly see, my lord, wherein this is the principal, my lord, Ashish Das, who has filed this affidavit.
So now in view of a criminal case being pending,
Yes.
is it open for him to accept it?
Of course, my lord. When I am the in
Who
charge,
lost the FIR?
my lord,
Who lost the FIR?
he have lost the affair.
He lost the FIR. He's the complaint. He's the informant.
Absolutely, my lord. No, my lord. Before lodging of the affair, this has come on evidence on record that I was in charge principal. I went for, my lord, my treatment and leave was granted. After returning, I tendered this amount. By way of check, my personal check, he did not accept. By way of bank draft, he did not accept. What is my alternative?
You adjust this amount.
Yes, my lord, that can be done, my lord. But no liability certificate he has to issue, my lord.
No liability certificate has to be issued by the principal.
Principal, he is not
In
issuing.
fact, I have received the instruction and that is there, my
Who
lord.
is for the principal?
Respond number 5, my lord.
Yes, only because of no liability it is pending. But the principal cannot issue no liability in view of the dispute. There is some amount you admit.
My lord, whatever it is, I am ready to pay. I tendered it.
No, that's
before
all
the
right.
case.
That's all right. But this no liability can't be issued unless this dispute is settled, that whether it is not your case, you are not denying that this amount is not with you.
No, my lord, I'm not
You have
denying it.
admitted. On the
Even
contrary, you have admitted.
I tendered it. After my return to school and joining, I tendered it. He refused to accept.
Of course, he'll refuse to accept because he's the informant. It is on that basis he has filed the FIR for which the
My lord.
criminal proceeding is pending.
Yes, sir.
Because if he accepts it, it'll be your trump card before the trial court that there is no case now.
No,
Matter
it
is
cannot
settled.
be, my lord. My lord,
That we are not on this.
my lord, the cross-examination part, may I take your lordship to 106?
No,
my
we
lord?
are not going into your cross-examination. What we are saying is that if you admit that there is an amount,
Yes, I tendered it. He's not accepting it. What can I do?
he cannot accept it in view of the fact that he's an informant. Why will he accept
He
it?
become informant subsequently, not that time, my lord.
All right.
And this is accepted by him.
Yes, what do you say? Yes, counsel. Yes, tell us.
Lordship, but I have to take instructions.
What instructions do you want?
That's right.
You have to issue the what is that, non-liability and audit report.
Yeah.
You issue that certificate. If you can't issue, you can't issue. You say that you cannot issue because of this. Have you responded to the department?
I have responded for the pensionary benefits, which
Have you seen this letter, Mr. Who has given this letter, Mr. Kharonia? Do you have a copy? Please share it with the councils. Oh, you have to video conference. Let them have a look. Give it to the petitioner, give it to the respondent.
no, Lordship, we have not received any copy about.
By the retiree, my lord, that is
Papers
so,
are
my
to
lord.
be
I can
forwarded.
submit my.
Papers are to be forwarded
By the principal.
by the principal to whom? Inspector or director?
Inspector, man.
Inspector of
Inspector.
schools, then to the director, man.
Director of pension.
Here it
Pensionary,
has been mentioned, my lord, non-submission of non-liability and audit report by the retiree. I'm not required to submit it. It is a principal who will submit.
regarding the auditory benefits which she will get, we have submitted about all those papers, even before her retirement, we have submitted. And regarding the no liability, then we have to confirm about it. We have to, for that we need instruction. Annexure number 6, from annexure number 6 to annexure number 11, we have stated, inform the higher authority to release an auditory amount.
Page number?
Page number 144. And that was before her retirement. That is on 5/10 of 2021. And she retired on 31/12 of 2021.
This is for requesting for audit.
Yes, Lordship.
Then?
Regarding the no liability, we have to
Is an audit required for finalization of pension?
yes, Lordship.
Under what provision?
Provision.
You complete your instructions. You can't hold on to a person's pension.
Yes, Lordship.
Then he is not provided by you from your own pocket.
Any short date maybe.
You explain your client that there are penal consequences for withholding of pension if the court comes to a finding. His or her pension will be in difficulty if we have to order. You are inviting audit against your own school? For what purpose? Who will invite an audit?
That's the ego clash going on, my lord.
6th December.
Sick.
Get your instructions.
Deeply obliged.
6th.
6th.
Mr. Khatuniar for education.
Education.
MS so-and-so for respondent 5. Mr. Mozumdar for
Respondent 6.
respondent 6. Mr. Soikia for pension department. Mr. Your name? M. Ahmed for accountant general.
Obliged.
List on 6th for instructions to be placed by the council for the representing the school. Yes.
Non-payment of family pension, madam. Petitioner, husband of the petitioner, my lord, retired in the year 2004, my lord, and thereafter his post was regularized in the year 2005, my lord. And in similar circumstances, my lord, case 29, my lord, his honorable court granted, my lord, family pension, my lord.
You are directed to file an affidavit.
Yes, well, explaining, my lord.
The delay. Have you filed it?
No, my lord.
Then?
But,
There's an order of the court. File it.
my lord, then 2 weeks time may be granted.
Mr. K.R. Patgiri, learned counsel for the petitioner, prays for and is granted 2 weeks' time to file an affidavit explaining the delay in terms of the order dated 28/06/2023 passed by earlier by this court. List after 2 weeks.
Obliged.
Mr. Dhor appears for the respondent department.
May I please, your lordship?
Yes.
Lordship, kindly pass over for timing. Lordship, my senior is Lakam court number
Not
6.
today, not today. Then we'll come next week. Next week.
Obliged.
Yes. Series. Yes. Yes, Mr. Somua, what in the notification have you given which neither of the parties are able to understand? Increment.
I'll try to explain to you.
Yes,
Let me take up item 10, my lord.
item 10.
And I filed, in almost all the cases I have filed affidavit, my lord, this will cover everything, all the cases. My lord, it says, my lord, UGC's regulation said that one who has been entered at the time of entering into the service is in possession of a PhD degree, they shall be immediately given advance increment, 5 non-compounded advance increment.
What is the meaning of non-compounded?
Non-compounded means suppose at the time of having the PhD degree, if the person is, suppose his basic salary is 10,000 rupees. And after giving him advance 3 or 5 increments, it comes to around, suppose 11,000 rupees. This 1,000 rupees increments, advance increment, shall not be counted along with the basic while he will be getting his normal increment in the next year. Am I clear, Miller? Generally, what happens, one increments added to the basics, then in the next time, that increment becomes a part of the basic salary, and then suppose 3% is the increment. If it is compounded, had it been compounded, then it would have been in the next year, his increment would have been on 11,000 rupees, not on 10,000. So when it is non-compounded, then the next year increment will be on the original basic salary, not on the advance increments.
So his case is that he was given increment in the year 2011.
11.
He becomes eligible for increment in the year 2007 or 8. Because this policy, this benefit is from 2006.
Yes.
He attained his PhD in 2007. So he says, according to him, he is eligible for 2008.
Yes.
Now he gets 3 increments, non-compounded. So he got his increment from 2008.
And the moment he got the PhD degree while he's in service, he will get 3 increments, advance increments.
Now, the department's view is that his increment should have been with effect from 2008, not from 2011. Therefore,
because he obtained his PhD degree in 2008 or 2007 for that matter.
So therefore, they are seeking a recovery. Now the question is,
seeking a recovery on what amount?
On the increment which has been given from 2011. Where is that order? In item number 10, you have not seen that order? Impugned order?
That order is at page 44.
44 to which item?
Item number 10.
Okay. No, Ramesh, that's the side.
44.
Monish Sharma, sir.
Sorry, Manish Sharma. Yes. We'll take your delay. Yes, ma'am.
44.
Page number?
44?
Yes, yes, ma'am. In terms of government instruction obtained in OM number written so the in supersession of earlier order issued on so dated so the 3 non-compounded advance increments are hereby allowed to Dr. Manish Sharma, Assistant Professor of Nalbari, raising her pay at rupees so in the scale of pay for acquiring PhD degree in 2006 instead of rupees 52,000 with effect from so in the scale of pay rupees so which DNI on 1/7/2013. Principal Nalbari College is hereby directed to calculate the amount payable to the teacher concerned due to advance increment of the date of advance increment with effect from so along with calculation of overdrawal of salary resulted. Well, that I have not understood. Like, what is this? What they are trying
This
to
is on
say?
the basis. This is on the basis of your circular.
I don't know, Malad, why, how they have calculated that there is an overdrawal. Since there is a question of recovery, there must be some overdrawal.
No. See, this is why this is what we want to know, as per the UGC norms, as per the UGC circular, this increment is for how many years?
Once its increment is given, it is added.
3 increments.
Yes, ma'am.
Once the 3 increments are complete,
Huh.
no further increment is called for.
I've not understood.
You are given 3 advance increments.
Mine.
Now 3 advance increments will be added to your basic pay when?
Once it is given,
Now, for calculating, as you say,
so immediately next 3 succeeding years, there will be no increment. Because he has been given already. Huh.
So once these 3 increments are given, no further increment is required.
So
Advance
from
increment.
fourth year,
He'll get his regular increment.
it will be calculated on this amount.
He'll get his regular increment.
Yes, regular increment. Then when on fourth year, this regular
So-
increment will be calculated along with this, my lord.
So therefore, this is exactly what has happened, and which is what we told you in the morning. If you look into this order, this increment, if it was given in 2008 or 2007, your basic pay at that time was 34,760.
Yes, sir.
So on that basic pay, the advance increment was calculated and
Yes.
given to you.
Yes.
Ought to have been given to you.
Ought to have been.
It
Yes,
was not.
It was not given.
It was given in the year 2011 or 12, when your basic pay increased to 52,011.
Yes, Your Lordship.
So therefore, the government decides that this is a wrong calculation. To that extent, your
Yes.
advance increment should have been calculated on a basic pay of 34,000.
Instead
Not
of
on
52,110.
To that extent, they are seeking a recovery.
No, it cannot be in my humble submission, because in that case, what they have not given me, that will be an arrear demand from my part.
No, because this is only for 3. That is why I'm asking you. This is only for 3 advance increment. Where either you get it in 2007 or 8, or you have got it in 2011, and end of the story. You can't claim for another 3 increments as arrear. That will amount to 6 increments.
No, it will depend upon the persons to persons who have completed their PhD.
You're right. You completed in when?
In this
In
case,
this particular case,
in this case, I have
2008.
completed on, I'll just 23/3/2006.
6, yes.
And the scheme started from
It was 1/1/2006, Your Lordship.
1/1. So you are eligible.
Yes, Your
Yes,
Lordship.
he is
So-
eligible.
so
Eligibility is not
your-
in question.
Your increment ought to have been calculated on the basis of the basic pay in 2006-07. And the amount that is calculated, the benefit you get, ought to have been given to you. It was not done.
But
It
one-
was done at a later stage when your basic pay was higher. So, is it the increment is not a fixed amount? It is a
Increment is
percentage.
based on the basic.
It's always on the basic. So higher the basic, higher is the increment.
Exactly.
In my understanding, my lord, there will be a very minimum amount of recovery.
Whatever it may be.
So, my lord, may I pray, my lord, if not inconvenient, my lord, if the higher education produces the records with the actual calculation on what basis and what is the
This
amount.
calculation, they have left it to be done to the principal.
So that is what, my lord, that can be done by even by the director office also.
And therefore, I'm
Because the
saying, Your
mathematics
Lordship-
is known to them also.
Your Lordship, therefore, I'm saying if you would have been put to notice, we could have replied to it suitably, Your Lordship. Therefore, I'm saying, Your Lordship. The only humble submission is that I have not been put to notice, straightway this order has been passed without any calculations. I could have justified my stand. Because every person stands on different footing in terms of PhD, Your Lordship. So this should be set aside, Your Lordship, and you should be put on notice if there is something. That would have been the best way of.
So, yes, higher education, who is appearing for higher education? You have not started on the recovery.
In 2 cases, recovery has been done, Your Lordship, because 2 persons have retired by now, in my case. And the other increments, they have stopped.
On what basis has the recovery been made?
Your Lordship, the pensions were stopped, Your Lordship,
Hmm.
and other pensionary benefit was not released. So accordingly, I was told that if you allow me to make this recovery, we'll release your pensions. Otherwise, the pensions will be halted.
Hmm.
Because while we filed the case, these persons were in service. Only 2 of them have retired. I prepared a chart, Your Lordship. So these 2 persons have gone for refunded the amount, so that their pensions can be cleared.
You
Your
give
Lordship.
us the amount to be recovered in respect of each of the petitioners.
Lordship, that can be done, Lordship.
Do it.
May I pray one thing? Subject to this honorable court, your lordship, let this notice be set aside, this impugned order be set aside, remanded back, put us on notice, we'll come and justify.
What will you explain?
That if there is any access drawl made on us.
Of course it is. Going by this order, it appears to be.
No, your lordship, we could have said
Prima
that
facie, it appears to be.
in that case, your lordship. That could have
That
been
is why I
adjusted.
was asking you, what is the UGC notification saying? UGC notification says you are eligible from
Yes.
2006,
Yes, your
the
lordship.
day you complete your PhD.
Yes, your lordship.
Now, the day you completed your PhD, let us say in the first case is 2007.
Right.
You are eligible from 2008, 3 years, 3
Yes.
increments. Your basic salary in 2008 and your basic salary in 2012 or 13 will be different. So naturally, the calculation of increment will also vary.
Right, your lordship.
Now, this is not your fault. This is the fault of the department.
So and that's why, your lordship, in these cases, two of them recovery has been made and the rest of the
We'll
increments.
deal with it.
And the rest of
But
the increments
the-
have also been stopped.
This
your
is
lordship.
in question to your submission,
Yes.
reply to your submission, that you are affected by not being put to notice.
Yes, your lordship.
What will you explain?
Your lordship, we can explain that what should have been the amount we could have calculated.
You
based
show
on-
it to the court, later you satisfy us, then you satisfy us. What is the amount?
That.
How there
explanation
is no excess recovery? You satisfy us, we'll examine it. If we find that, yes, this is an area that requires personal hearing, we'll direct it.
Then your lordship may keep it, we'll get it and we'll place it here. We'll prepare it.
Is what you should have done, that this is the amount, it does not affect them, a negligible amount or small amount, or it can be adjusted later. You should have done it.
But otherwise also it can be, it could have been.
Mere violation, on what basis are you urging that natural justice is violated? It's not an empty formality. You have to show your prejudice. How are you prejudiced? Yes, recovery, you are prejudiced. What basis? You don't know.
I could have understand, your lordship, they have said that the recovery has to be done.
Now, in respect of these two persons who is retired, has the calculation been made?
That will be known to the principal and the diagnosis.
Mr. Sinha,
Yes, your lordship.
you said some recovery is made.
Yes, your lordship.
The calculation has been made by the
Yes, your
college
lordship.
authorities.
I've just, no, I have asked my clients, they have said something. I'll just put it on your lordship on record.
You get the calculations. The education department also. What you want to recover?
How much amount?
Petitioner
Petitioner
against a
against a
clearly on affidavit.
I heard learned counsels for the parties. In order to effectively decide this matter, what is required is the amount sought to be recovered by the department pursuant to the impugned order. Where is the impugned order?
Lordship at page 44 in item 10.
Dated, all are dated the same day.
Yes, your lordship.
25
2005-2019 issued by the Director of Higher Education in respect of the 3 advance increments issued to each of these petitioners. Stop. The
Your
recovery
lordship.
sought to be made.
Your lordship, in item number,
Wait. Recovery sought to be made by the department in respect of each of the petitioners, in respect of the 3 advance increments. Shall be quantified and placed before the court by the next date fixed.
your lordship, in item number 12, Dr. Narayan Chandra Burman, he has retired, your lordship. His recovery is 4,46,702. That has been done by them.
We'll take it up on the next day. You tell us how much time you require.
वो बेसी टाइम ना लगे.
Placed in January.
No, your lordship, it can be taken up in December also, your lordship. We'll get it.
December.
I'll get it only in 3-4 days.
You tell us.
December 11, your lordship, I'll get it done by then, your lordship.
My lord, we record our presence.
13th December.
Your lordship has kept it part your lordship.
We'll list it on 13th. Let us see.
Yes, sir. Lordship, we record our presence.
Mr. Tomo appears for the UGC. You are not a party here.
No, I'm not.
You are a party here. Then why are you apprehensive? We will not record your presence. We record all council's presence.
Well, but nowadays, many emails comes because everybody can see everything on internet. So if names are not reflected, then the queries come from the clients, "Ki, you are not there, your names are not there." That is fine. Otherwise, no problem.
Okay.
You should tell your clients that you are omnipresent, even if the names are not
Oh,
there.
that's-
You are available.
Deeply obliged, your lordship.
Highly
Yes.
obliged, Lordship.
List on so and so date. Report by the learned councils.
May I please, your lordship. The petitioners are appointed in the year 2001, your lordship, as systematic disarranged against the vacant post, and they are entitled for the old pension scheme, but it is not provided. And this issue already decided by this court in common judgment. By placing on judgment, your lordship is already decided.
Who's for the respondent?
Higher elementary education is there.
Who is for the elementary education? What judgment?
On the basis of that common judgment, one the order passed before. On the basis of that common judgment, the same similarly to that person.
Yes. Mr. Nayak, you are appearing?
Lordship, I am appearing for finance department, Lordship. Lordship,
Yes.
if this is agreeable to the department, Lordship, then Lordship may send this matter back to the department to verify in terms of this judgment, Lordship. And if it is applicable, then they will pay like that.
You are what teachers? Stipendary?
Lordship. They are appointed in the 2001. Paragraph 2 of my petition, I have given a chart in 5 petitioners.
It has already been decided.
Decided.
Mr. Nayak? Okay, hard disposed.
Of that.
Huh? Some compilation was required. to
Yes,
prepare.
madam. But one thing, that escaped or notice, my lord.
Lordship, only thing is, Lordship, I have not received the cancellation order, Lordship.
What order?
The cancellation order of their Lordship regularization. In the course of Lordship hearing.
Have you prepared the compilation?
Yes, madam.
You circulated?
My lord, circulated also, my lord. Some by hard copy, giving hard copy, some by my lord.
No,
Soft
why?
copies by
You
lord.
should have been here.
My lord, court of course, I can place now. One thing, my lord, escaped or notice, my lord, in one of the cases, my lord, item number 22, perhaps lordship was appearing, my lord, for the department.
Oh. then it can't be.
Item number 22, my lord.
22, no?
Not the law, Purana, very old case. Very old case, my lord. That's why.
Oh. What is to be done? Segregate.
Let's agreement.
All right, before any other bench without me.
Lord, you can segregate this case, my lord.
How can we?
I take 24, my lord. That is investigated by department, my lord, where the law was not there. And that issue has already been decided in this case, my lord. That case may be disposed of, my lord, in the line for compliance with the earlier order, my lord. That issue was decided by Honorable Court.
It is already connected by a judicial order, so it should be decided. Let it be decided.
In this case, my lord, nothing is to be decided because my lord, already the issue was decided.
See, when one matter, I cannot take it up, and by judicial order, these matters are connected. Now again, to decide whether this matter is similar or not, we are addressing this issue. So better to release it, place it before any other bench without me.
Short that
In view of the order dated.
I was like before the time road
Order dated 14/3/2013, issued in WPC 1202 of 2013.
Maybe on 7th, my lord. 7th December.
7 December, list on 7 December.
Hello. Lot of 7th, I will be out of it. Let it be 8. In the next week, second week, Lord.
Since this is out of my rooster, you choose your date. No difficult. Whatever 7, 8, 9, 10, whatever date you want.
Lordship will not fix any date then. No, that should be fixed.
This is an
All
old
very
matter.
old. 7, I have problem.
No,
Eight,
7
let it
is
be
your
8.
problem, then let it be on 12.
12.
12th of December.
Even I'll, so 14, my lord. 12 will have some. 14. Still, I'll not be available.
14 December.
14 minutes.
Oblige.
For appropriate bench. Yes, 27.
Yes, my lord. My lord, here bank, council of the bank, my lord. He is absent, my lord. Respondent number 328, represented by learned counsel of the bank, my lord.
Dismissal matter.
Yes, my lord. We have made an inquiry. Earlier, advocate says that.
Which
there are
bank
no
is it?
more-
Indian Bank.
Yes, Indian Bank.
Standing
there-
Council, Indian Bank. All right,
Last occasion.
passed over. We'll wait for him. Let us see if he comes.
My lord, I am again.
Yes.
This petitioner, your lordship, was the sectional assistant. He was dismissed by the bank authority after holding a disciplinary proceeding.
Hmm.
My lord, the statement of allegations or the charges, my lord, your lordship will find at page 17.
What is your basic ground for challenge?
My lord, my basic ground is, my lord, this is a case of, my lord, no evidence. And the, my lord, findings are absolutely perverse, my lord. These are the, my lord, basic two, my lord. Nothing has been proved in the, my lord, proceeding.
Records?
Lordship.
Records available?
Because bank's records were never told, your lordship.
No, for deciding a matter of inquiry or evidence, we'll need the records. go through.
And the last.
Where is the inquiry report? 24.
Yes, my lord. This, on the last occasion, Lordship has.
No, this is how the bank normally furnishes inquiry reports.
Lordship.
But the details are available in the.
My lord, those copies are with me, my lord. On the last occasion, Lordship has directed them to be ready with the record. my lord.
Ah. I think last order we had said something about the records.
Only the,
Do you, have you enclosed any copy of the statements of witnesses?
statement, I have not enclosed, but I have the copies. But sort of, my lord, records will be producing. So, my lord,
Or do you produce your records? This matter being a matter of dismissal from service. And the challenge is made to the order of dismissal as well as to the inquiry report. Inquiry, disciplinary proceedings conducted on the basis that it is a case of no evidence against the petitioner. The relevant records pertaining to the disciplinary proceedings initiated against the petitioner will be necessary for perusal of the court. Let the records be produced before the court by the next date fixed.
not inconvenient, my lord, 6th.
6th is not at all possible.
14th, your lordship.
14th already. 14th.
I also submit the, the proceeding of the disciplinary committee.
Who will submit?
I'll also submit, my lord, the addition.
The records are there.
Record.
If the records are produced, we'll go through the records. They're in English, I hope.
Lordship.
Yes.
Lovely.
Your lordship.
Yes.
Regarding the departmental proceeding, your lordship, I have given a judgment. Prem Singh, Premnam Bali, copy of the judgment is there. So-called notice was issued, your lordship, on 17/2/2022, annexure 7, page 44. Your lordship. Page 44, annexure 7. And we submitted.
Who's for the respondent? Who's there? Forest.
Forest, your lordship.
Forest. Display. Forest.
No more than 1.5 years.
It has not been completed.
No, only inquiry officer has been appointed, nothing new. And I am going to retire in January, your lordship. Due to tendency of the DP, my due promotion has been, I have been denied due promotion. My juniors have been promoted, your lordship. As per this decision of the Honorable Apex Court, your lordship, at best it has to be completed within 1 year. Already more than 1 year, 10 months, 9 months. So I pray for disposal of the case, your lordship, for costing the departmental proceeding.
Let the other side appear. You inform him. We are keeping it aside for the time being.
Yes.
Yes, Mr. Chakraborty.
Yes, my lord, I have gone through the judgment. Now that judgment is on a different footing. In that case, the question was whether the disciplinary proceeding initiated after his retirement. And in that case, the file was moved to the Chief Minister's office. And in that context, this Honorable Court held that it was fairly proceeded as the governor under Article 163 functions with the aid and advice of the Council of Ministers. Now, my lord, if your lordship takes up this Rule 21, it is the governor who reserves the right.
Yes.
Now, the starting words, the governor of Assam reserves to himself the right.
So your submission is that
It is,
it has not been forwarded either to the governor for his decision in the capacity as a independent decision,
yes, or as a,
or on the aid on advice of the
yes.
council.
Because till today, in spite of the opportunities granted, there is no order as such whereby the government has taken a decision to stop or withhold or deny pension. Withhold either wholly, because the language is clear. The governor has the right of withholding or withdrawing a pension or any part of it. That means withhold or withdraw. Withhold means it can be kept in abeyance for a particular period. Withdraw means withdrawn completely, either full or a part. So in this case, Lordship will see, apart from an order whereby the government has issued an order to stop the provisional pension, there is nothing to show that any exercise under Rule 21 was carried out. Now, Lordship, if your Lordship takes up Rule 22, Rule 22 speaks of a situation where the proceeding is pending. During pendency of the proceeding after retirement, provisional pension will be paid. No issues on that matter. After its conviction, there cannot be any question of provisional pension because that proceeding has come to an end.
What is the procedure for obtaining the?
Mala?
What is the procedure for getting the sanction of the governor as per the rules?
Under the pension rules, there is nothing under the rules of executive business. It is the file is routed and it is the governor will have to take a call.
Executive rules. Do you have a copy of the rule?
No, my lord, I have it.
That is there in this book.
Services manual.
The Assam rules of executive. It should be page number 208 in this book.
Rule 12 says that every order of the department shall be in the name of the governor and has to be passed by the secretary, chief secretary, principal secretary.
Rule 12.
Rule 12.
12. My lord, page number perhaps 211.
Now, assuming, my lord, but there has to be an order first. Here, in that case, my lord, which your lordship has seen on the last occasion, there was a case where the decision to initiate the departmental proceeding was challenged on the ground that it was not properly sanctioned by
Where is that order? Where is that order?
Which order, my lord?
The order
Of this court.
Impugned.
My lord, there is no impugn order.
Lord,
Now, there is no order as such in this case. That is why, after my conviction, they have stopped the provisional pension. And there is no order as such showing withholding or withdrawing of pension.
There is no order.
Yes, that is what I am trying to submit before a lordship. We have not challenged any order because there is no order at all. That is why on last occasion, that is on 2/6, there is an order of this honorable court directing them to produce the order. Lordship may have a look at the order of 2/6/2023. To produce them that order by which the decision to stop or withholding the pension was passed. And they could not produce any order. Though an additional affidavit was filed.
Lordship, an additional affidavit kindly come to running page number 37, my lord. Annexure 2.
37.
37. Running page 37, lordship.
Of what? Additional affidavit.
Additional affidavit, lordship. Or in our additional affidavit, lordship.
Yes, 37.
37, my lord. That is the one opinion of the undersecretary to the director, lordship. There is an opinion of the legal department, my lord.
No, but there must be some order to stop the
36,
pension.
lordship.
Yes, there is no order.
Lordship, it's at 36, page number 36, annexure 1, lordship.
Ah. This is the order. On what basis this order has been passed?
No, my lord, this is not an order of stopping pension, my lord.
We
This
tell.
is an order to stop further provisional pension. My lord, after the conviction, there cannot be any provisional pension, either full pension or no pension, or a part of pension. This is the order of 2010, directing to stop the provisional pension any further. And the next order, it cannot be an order passed subsequent to this 12th October 2012 order, because this order at page 37 is dated 12th October 2012. So the order at page 36 cannot be an order in consequence of this letter.
That is an earlier order.
Yes.
2010.
Yes. So after, because if your lordship takes up the first affidavit, your lordship will see that
Pursuant to 2012, there is no order
no order.
No.
And my lord,
in the file.
I have all the records, my lord, but in 2013, there is another order.
You go through it and tell us why you.
that is why, my lord,
That is
on
from the
2/6 that
directors
if
to the
order was passed to place on record that order.
Lord,
And
may I read, Master? In inviting a reference to the letter on subject cited above, I have the honor to inform that pursuant to the government order under reference and as per Rule 21 of Assam Service Pension Rules 1969, it appears that Sri Makibul Islam has been found guilty of misappropriation of government money and also causing pecuniary loss to the government, as per order of conviction passed by the Special Judge CBI Assam, and therefore it is hereby proposed to withdraw the pension of Sri Makibul Islam ex UDA cum accountant under Rule 21. However, in the aforesaid rule, it is provided that before issue of financial order, approval of, perhaps why FPSC is necessary, I don't know why FPSC.
no,
is
the rule
necessary.
says.
And I have, in view of the above, I would like to request government kindly to examine the matter and convey necessary instructions for issue of the personal pension withdrawal order of Ms. Makibul Islam.
Again, that is a
That
proposal.
That
It is not
the
an
proposal
order.
of 16th May 2013, Lordship.
Then
Rule 21D. The Assam Public Service Commission shall be consulted before final orders are passed.
Then
That order is reflected in the affidavit. That is the director, it's a letter of the director for processing the case of the petitioner to the government to take an appropriate decision. Now there has to be an appropriate decision, either withholding or withdrawing wholly or part. Again, there has to be an assessment whether there is any pecuniary loss, because no
order
departmental,
to be passed by whom?
by the departmental secretary. Because under Rule 12, in the name of the governor, order has to be passed by the
The
department.
name of the governor cannot be
No, my lord,
so
what I have
lightly.
understood, there has to be an order. Whether the order was properly passed or not, this is a subsequent question which requires an adjudication. But there is no order.
There is no order is on.
No order as such. So that exercise is premature, whether it was properly done or not. What my learned friend is reading, that is a proposal of the director that in view of his conviction.
Any proposal was sent.
My lord, from the record, I have not.
No, that you read out.
Yes.
Is in the note sheet or is it a proposal?
Is it a?
It is a letter, order.
Lordship, order.
It is an order of the directors.
It's an order of the director.
Yes, it is an order of the director. Your lordship may have a look at the first affidavit. In page number 5, that part has. That is an affidavit sworn by director.
16.5. Is that the proposal?
Yes, last paragraph of page 5. It appears the
16.5.
yes. Therefore, the office of the directorate proposed to withdraw the pension of the petitioner. That under Rule 21 of the Assam Pension Rule. In this regard, the office of the directorate by letter dated so and so submitted a proposal to the government for necessary approval of the government as well approval of APSC as required under the law to issue the final withdrawal order of the petitioner. It is stated the matter is now under process. So when the first affidavit was filed on 2013, it was under process. Thereafter, it has not come up, or we do not know till today.
In the subsequent affidavit, anything?
No.
In the additional affidavit?
No. There is no order.
No other order in this record, Lordship. And this is the last order of 16 May 2015, Lordship. 16 May 2013, Lordship.
To whom has it been addressed, the proposal?
Proposal has been addressed to the Commissioner and Secretary, Government Animal Husbandry Department.
Yes. Anyone else? Accountant General?
Accountant
General, my lord, comes in after.
It has not even gone there.
Yes.
That far. Heard learned counsel for the parties. The writ petition is filed with the petitioner. Assailing, or you write seeking a direction from this court to the respondents for release of his pension
and other retirement
retirement benefits. Stop. The petitioner was appointed to the post of lower division assistant cum typist under the office of the veterinary department, animal husbandry and veterinary department. He was subsequently promoted and he superannuated from his services on 31/5/2004 as UDA. Stop. During his service period, certain criminal proceedings were initiated against the petitioner, which ultimately whereby the petitioner was convicted and sentenced to suffer rigorous imprisonment for 2 years and a fine of rupees 20,000. Stop.
Several punishments, my lord. 2 years, fine, another for under different
for offences. You see from page 6. Huh? And
on 29/12/2006. That is the order of the special.
Pursuant thereto, the petitioner filed an appeal before this court, being criminal appeal number 15 of 2007. Stop. During the pendency of the criminal appeal, upon completion of his sentence and on payment of fine, the petitioner was released from jail on 10/9/2010. Stop. Thereafter, upon making necessary inquiries, he came to be informed that his provisional pension was stopped with effect from 1/6/2007 without there being any specific reasons assigned. Stop.
he was paid provisional pension from 1/6/2004 to 31st
The
5/2000.
the learned counsel for the petitioner submits that pursuant to his superannuation on 31/5/2004, he was paid provisional pension with effect from 1/6/2004 to
Up to 31/5/2007.
up to 31/5/2007. Stop. With effect from 1/6/2007, his provisional pension has been stopped without there being any specific order. Stop. Petitioner represented before the authority requesting for release of his pension, regular pension, by the representation dated 29/9/2010, which has been pending before the directorate. Stop. However, in spite of representing the authorities, his prayer for grant of pensionary benefits have not yielded any result, and the petitioner has been deprived of his pensionary benefit. Stop.
Pensionary, my lord, as well as other
As well
retirement
as
benefits.
other
like-
retirement benefits. Stop. Learned counsel for the petitioner, referring to Rule 21 of the Assam Pension Service, Assam Services Pension Rules 1969, submits that it is the governor of the state who reserves the right to himself for withholding of any pension or any part thereof. Stop. Learned counsel for the petitioner, referring to Rule 21 of the rules, submits that there is a proper procedure prescribed under Rule 21. And this Rule 21 specifically provides that it is the governor of the state to whom the right of withholding or withdrawing of any pension is reserved. Stop. Learned counsel for the petitioner submits that as on date, there is no specific order withholding or withdrawing his pension passed by the appropriate authorities in terms of Rule 21 of the pension rules. Stop. He submits that because of sheer neglect of the department to address this issue, the petitioner has been deprived of his right to have the pension as prescribed under the rules of 1969. Stop. Notwithstanding that the petitioner has been convicted in a criminal case, and at the relevant point in time, what is the status of the appeal?
My lord, that has been dismissed. I have taken the instruction. That has been dismissed and he has served his sentence also. He
And
was
the
released from jail on 10/9/2008.
subsequent dismissal of the criminal appeal.
And he served his
fact
sentence and
is
released
that
on
the petitioner
10/9/2008.
has served his sentence and paid the fine. And therefore, there is no occasion for the respondent not to release his pension, more particularly when there is no specific order passed by the authority. Stop. MM Kotoki, learned counsel for the veterinary department, submits that an affidavit has been filed by the department contesting the claims of the petitioner. Stop. In the said affidavit, it is submitted by the learned departmental counsel that an opinion of the judicial department was obtained and pursuant to a proposal for withdrawal of pension of the petitioner has been submitted before the competent authority. However, no specific order is available in the records to be placed before the court. What is there in the additional affidavit? Same thing.
Same,
In the
Lord.
additional affidavit, they are referring to that only.
In the additional affidavit, we have given these two letters in this lordship, by which communication his pension has been stopped, lordship. It is of 23rd February 2010.
In the additional affidavit in opposition, two communications are referred to by the Learned Standing Council, namely communication dated 23 February 2010, whereby
And 12th of October 2012, lordship.
and 12th October 2012, whereby pursuant whereto the provisional pension of the petitioner has been stopped. Para learned counsels for the parties have been heard. Pleadings on record have been carefully perused. Are you relying on any judgments?
My lord, I rely on a judgment of this court, single bench. He says under Rule 21, it is the governor who has the power to exercise.
Mr. Counsel for the petitioner has relied upon the judgment rendered in so and so in support of his contentions that it is the governor. Under Rule 21 of the pension rules, it is the governor who has the right, who is empowered to withhold the pension. Stop.
And lordship may also refer to the 2/6 order direct issued by this court, by which they were given a direction to produce that, and they have failed.
Its judgment will come after his learned counsels for the parties have been heard, pleadings on record have been perused, and it is seen that during the course of the hearing earlier, direction was issued to the Standing Council Veterinary Department to produce the relevant records to show the orders that may have been passed for stoppage or withdrawal of pension to the petitioner. Stop. In pursuance to the directions of this court's order dated 23/11/2023, Learned Standing Council has produced the records of the case. Upon careful perusal of the records, no specific order has been seen whereby the pension of the petitioner has been stopped or withdrawn by the department. Stop. What is seen is that a proposal for stoppage of pension was forwarded by communication dated 16/5/2013.
16/5/2013.
16/5/2013 for necessary approval of the government as well as approval of the APSC as required under Rule 21. Stop. Of the pension rules. Stop. However, pursuant to this proposal, no specific orders are seen in the file to show that the department had considered the issue and passed the necessary orders as required for stoppage or withdrawal of the pension in respect of the writ petition. Stop. Upon considering the rival submissions of the parties and upon due perusal of the pleadings on record, the mandate of Rule 21 under the Assam pension rules is required to be referred to. Stop. Rule 21 of the pension rule reads as under. Extract this rule. Stop. A bare perusal of the rules clearly reveal that it is under Rule 21 that an employee's pension can be withdrawn or stopped. It is categorically specified in Rule 21 that the power for withdrawal or stoppage of pension is reserved only for the governor of the state, namely the governor of Assam, in the context of the present proceeding. Stop. The rule does not provide for any exception to for issuance of any orders for stoppage of or withdrawal of pension. Stop. The powers of the governor are well defined under the provisions of Article 163 of the Constitution of India. Stop. Under the powers reserved for the governor of the state, there are certain functions which the governor is required to pass orders, pass or issue orders, and there are other matters where the governor is required to take into account and pass necessary orders only on the aid and advice of the Council of Ministers of the state. Stop. Be that as it may, upon taking into consideration the rival submissions and also upon careful perusal of the records, it is seen that as on date, there is no order either by the department or by the governor under Rule 21, whereby the pension or provisional pension of the petitioner has been stopped or withdrawn. Stop. Under such circumstances, the department is not able to support their stand as to under what provisions the pension of the petitioner has been stopped. Stop. Full stop. No order to that effect is available in the records or on the pleadings filed on behalf of the department. Records of the department or the pleadings filed on behalf of the department. Stop. There is no order as mandated under Rule 21 that has not been passed by the governor or by any other appropriate authority in the name of the governor for withdrawal or stoppage of the pension. Stop. As discussed, what is seen is that a proposal has been forwarded by the director. Who forwarded the proposal?
Director.
Director. As far back as so-and-so date, 2013. 16/5.
16/5.
2013. For taking necessary action in respect of stoppage of the pension, on which it appears that no specific orders have been passed. In these peculiar facts and circumstances, this court has to arrive at the conclusion that the stoppage of pension or stoppage or withdrawal of pension of the petitioner has been done contrary to the provisions of the rules, contrary to the prescription of the rules. Stop. In fact, there is no specific order available or issued by the department as on date for stoppage of pension. Stop. Such action cannot be allowed to be sustained in view of specific provisions under the Assam Services Pension Rules. Stop. The coordinate bench of this court in Harinath versus State of Assam reported in so-and-so has had an occasion to deal with a similar issue, explaining the powers of the governor under Rule 21 of the rules. Stop. Which is relied upon by the counsel for the petition. Stop. It has been repeatedly held by this court as well as by the apex court that pension is not a bounty. It is a right accrued under a specific statute, namely the Assam Services Pension Rules. Stop. The grant or withdrawal or stoppage of pension of any government employee must be in strict prescription of the rules under the statute. Stop. In view of the discussions held above, and in view of the fact that no specific order has been noticed from the records or from the pleadings issued by the department regarding the stoppage or withdrawal of the pension, this court is of the considered view that the prayers made in the writ petition ought to be allowed. The respondents are directed forthwith to release the pensionary dues to the petitioner after due adjustment of the amount which has already been released during as provisional pension. Stop. Unless an order is passed in terms of Rule 21, it is made clear that the stoppage of pension of the petitioner or the action of the respondents in withholding the pension of the petitioner cannot be allowed to sustain. Stop. The respondents are therefore directed to comply with the directions of this order within a period of 60 days from the date of receipt of a certified copy of this order.
Please, Lordship, please go to the
You'll have to send the
Accountant General.
proposals.
Within 60 days.
Yes. This direction is issued by the court, both to the veterinary department as well as to the Accountant General's office. Writ petition accordingly stands allowed in terms of the
My
above
lord, may I
order.
also please to specify that his other retirement date, lordship has given the pension
Pensionary and other retirement benefits, retirement
Pension.
benefits.
and other retirement benefits.
Yes, and other retirement benefits.
Rule of 9, no, it's not in the rule.
No.
Does it say about
Say
other retirement
other
benefits
retirement-
about the governor?
No. They
Pension,
have not. They have,
pension includes some other retirement
no,
benefits.
they have not released my pension and other retirement dues
That's what.
also.
That is what you
And
have
the
to.
reason is that the criminal case, if they have not taken a decision to release my pension, they're supposed to release my other retirement dues by this time.
Yes,
That includes gratuity and all.
60 days. We are making it clear to Accountant General also. So don't be sanguine that the department has not sent a proposal. You have to pursue it.
Obliged.
Obliged.
We are not inclined to issue cost. Because without any order, you have withhold the pension, which you can't do.
On behalf of KP, came up.
Yes, you put your names there.
The petitioner deserves some interest. In the case.
You first get the pension.
My lord. Obliged.
Bank. Who's this? Who's for the bank? Chennai. We'll keep it for next week.
Yes.
Please notify the bank council. Bank council to notify. Matter stands referred till next week in the absence or as the counsel for the Indian bank. What bank is it? Indian Bank.
Yes.
Is not available in court.
And first one, number 1 and 2.
In this matter,
Yes, sir. Just state of Assam and Home Department.
state is also made a party.
Because of some criminal case,
Criminal-
otherwise we are not really, we are just a
Mr.
formal party.
C.S. Hazarika appears for the state. 1 and 2. Let the matter be listed next week. Yes.
My lord, this amount of sanction and last date on though not recorded, my lord, there was admission on the part they received the benefits.
No, today I am for departmental proceedings.
For?
Regarding the pay for disposal of the departmental proceeding, your lordship. Subsequent allowance was
Departmental
already
proceeding.
paid. So I have been, your lordship, as I have pointed out.
Proceeding has been initiated. You have not proceeded with.
No,
It's going on, my lord. So, my lord.
no, nothing after appointment of inquiry in May 2023, nothing more.
Let me answer instructions. my lord.
What
No,
instruction I am
you
going to
complete
detail?
it, complete it. No instructions, you complete it.
No, as regards to appraisal code the stage, lordship may directly complete it, but lordship has to indicate at what stage it is. Lordship has to reflect in the order.
If you have completed well and
No. At this, lordship has to indicate in the order as at the what stage it is.
so whatever stage it may be, you complete it within a time bound period.
He's
What
going
is the
to-
difficulty in?
No, I'm not disputing that, madam, but since it's, if it results in some other recoveries, I just want a day, madam, just a day to apprise the court at the what stage, madam.
All right. Well, let us have it on Monday.
Yes, madam, yes, very well.
Otherwise, your lordship, earlier there was also commitment to complete it
There was
within
no
2
comment,
months.
no, madam, no comment.
No, but you are required to do it. In
Madam,
terms
we'll
of the
do it
law.
definitely.
I am going to return in January, your lordship.
Yeah, let the matter be listed again on Monday, 4th.
I'll apprise the
On
court,
which
madam.
date the learned counsel for the forest, Mr. D. Gogoi, will apprise the court regarding the status of
Madam,
departmental proceedings stated to have been proceeded against, stated to have been pending against the department, against the petition.
Fine.
Mr. R. Muzumdar appears for the petitioner. Mr. Hazar, you are appearing, Mr. Hazarika?
Forest.
All right.
Forest,